Welcome back to Aging in Place is a Team Sport. I am honored to have with me today Sarah Bidwell with Wills on Wheels. And Sarah is an attorney and she does something that is pretty rare for attorneys. She makes house calls. So, Sarah, tell us about Wills on Wheels.
So I get a lot that it's a catchy name, but it perfectly describes what I do and what I offer for clients. I am a mobile attorney. So I do mobile estate planning. I typically meet with clients in their homes or their financial advisor's office or the senior center if that's where they want to meet. But I travel to them to be able to put their primary estate planning documents in place.
Right. So, for people that the whole legal world is kind of a mystery and murky and really confusing. How would you break down and summarize what legal documents people should consider and at what stage in their life journey should they begin to think about these?
Definitely. So, first, as an attorney, we'll start with the disclaimer. Anything we talk about and is not necessarily specific legal advice. We'll go through some of those primary documents, but anyone's going to want to make sure they have an initial consultation with an attorney to make sure what fits them best. It's not one size fits all, especially for estate planning. And I've talked to someone today who said, I've Googled more things or I've looked online, and every article I read, I think I need something different. It's really confusing. And it is. There's a lot of different pieces, but there's a few primary documents that everyone can start with. So the most common is your will. Your will comes into effect after you pass. It names an executor. Your executor's job is to distribute your estate the way that's laid out in your will. And then your will passes through the probate process. But sometimes people want to try and avoid that or minimize that. So they can work with their accountant, make sure they have beneficiaries on their bank accounts, on any sort of retirement accounts, and to walk through each of those pieces. So your beneficiary is the person that receives assets after you pass away. That's different from an agent. So you may have an agent who acts on your behalf while you are alive. Then your agent would act under your power of attorney or your medical directive. So there's multiple different kinds of documents, but I do recommend if someone has questions on it to attend a seminar. There are seminars on estate planning essentials that walk through those primary documents, wills, powers of attorney, medical directives, deeds, trusts, to figure out what fits best.
So, I believe you do a lot of these seminars around the area,
Yes.
correct?
Yes. And I know you're really big into education as well. And that's the primary thing. So I present seminars at senior centers all over our area. I do a lot of presentations in Rocky Mount at the Essig Center. That's a senior center up there. I just finished up a series of seminars down in Stewart with the Virginia Tech Cooperative Extension. So a series of seminars there. And I present in Roanoke regularly. On my website, people could find if they want to look to see where I am going to be next. But I encourage that. Just come on out to the estate planning essentials class. Have any questions, we can walk through them, and then everyone can have a more basic understanding of what these documents are.
And you do those seminars at no charge?
Correct. Yeah. The estate planning essentials
Wow.
seminar is free. It's open for everyone to attend, depending on the location, but usually open to the public to come on in. So I will have adult children come in with their parents because they want to make sure they have things in place. I will have parents bring their adult children in so that they're on board as well and can go over any questions. A lot of times it's a whole family there. But they are free. The estate planning essentials class is free and that is open. And I've had people attend them multiple times. They may attend one, come back later with a family member or come back with a more in-depth question, but to be able to provide that basic framework. So even if they don't work with me, they can go out and know what they need to put in place and have a better understanding.
Yeah, that's awesome. That's really a great service because, normally people would, have to make an appointment at an attorney's office and go in and, pay hundreds of dollars to be
Just,
able to
yeah.
ask those questions.
Yep.
Yeah.
The whole concept of what I do is really based on making estate planning more accessible. Yes, I'm making it physically accessible by traveling to clients, especially if they can't get out of home. But the vast majority of my clients would be able to travel. They just like the convenience. So I'm making it more accessible, more convenient, and not trying to gatekeep anything to ensure that people have this in place because the more barriers we put to putting this in place, the fewer people are going to have their estate planning. I read a statistic that it's as high as over 60% of people that pass away without a will. And we're trying to overcome that.
Yeah. So let me switch gears for a moment and talk about power of attorney. I feel like there's a lot of misunderstanding about what that means. We think of an attorney as someone who practices the legal profession, and
Right.
obviously that's one meaning of the word. But when we say power of attorney, that means something very different.
So that is a common misconception. So power of attorney is another legal document. For me, it's one of the most important documents I help clients put in place because a power of attorney is you granting someone else the legal authority to act on your behalf. They are acting as your attorney, they're acting as your agent. So, depending on what you want them to be able to do, it could be something as broad as they are able to pay bills. They're able to manage insurance. They are able to sign deeds or sign checks. They're able to act on your behalf in a variety of ways. So it is powerful. We want to ensure that whoever you are naming is someone that you trust implicitly. A lot of times people will name their adult children. If that's not an option, they may name another close family member or a friend. But the critical piece is to have that power of attorney in place well before you need it. I've had people call and they want to have their parent or an elderly family member put a power of attorney in place. And unfortunately, that person no longer has the cognitive ability to do so. It may be something where they've had a severe stroke, they're unable to act on their own behalf, or they were in a severe car accident and they're unable to act on their own behalf. And at that point, it's too late to put that document in place. I mean, without that power of attorney, typically that family would have to go through a court proceeding to have the legal authority to act on their loved one's behalf. That's what.
So it automatically go to the next of kin. Let's say somebody had a stroke and they're in the hospital and the medical professionals need a decision about care.
So
Do they not
care is a
ask
little
those
bit
questions
different.
to Okay.
Healthcare is a little bit different. And in Virginia, we do have a code section specifically that outlines if care is needed and we need to make a choice, who is in line to be able to make that decision. So, care is a little different, but typically your power of attorney is used for financial matters. And there is
Okay.
no authority. Now, a spouse may be on a joint bank account and may have that authority, but certainly if it's an adult child, they're probably not on the bank account. And they have no authority to be able to do that, especially if the person's unable to communicate anymore. So, medical is a little different. We're going to make sure a decision gets made. Where the medical decision gets
Okay.
complicated is if two people disagree. So, if a spouse and an adult child
Right.
disagree.
And so if for financial matters, someone is incapacitated without a power of attorney, and then decisions about their assets or their accounts or paying their bills would have to be adjudicated by a court.
Yes. So if someone is incapacitated and there is no power of attorney, they're still physically here, but they're unable to act on their own behalf, then the court would need to get involved. And that process is called guardianship and conservatorship. And the court reviews what's happening with this person. Do they need someone to act on their behalf? And then whoever wants to apply for that, usually a family member, has submitted.
Are two critical factors that separate businesses in 2020.
Hello.
Sorry about
Welcome
that.
back.
So one of the things about being mobile is sometimes technology is fantastic, and other times, like this, your phone overheats. Just phone decided to overheat in the middle of this and just decided to quit.
Yeah. Well, your phone's not the only thing that's been overheating the last few days.
I know, and it's been very warm. So power of attorney. Yeah,
Right. We were
speaking back.
talking about talking about power of attorney and what happens if someone becomes incapacitated and they don't have a power of attorney in place
Correct.
and someone has to apply to the court for a conservatorship or guardianship. Is that two
Yes.
different things or
Yes, they are very similar, but yes, they are two
okay,
different proceedings. So if someone said, I just want to apply for one, or you have two different adult children who want two different roles. But with that proceeding and with that process, there is continuous court oversight and involvement. And usually that process takes quite a while. So it's not something that can be done on an emergency basis in 24 hours, where if a family member is in the hospital or if a family member is being scammed, you can get in there and clean up their finances quickly. It's a long proceeding. So I do strongly recommend that power of attorney document to try and avoid that guardianship and conservatorship process.
right? But at the same time, I would think that you would have to be very conscious of who you're giving power of attorney to
Yes.
and the extent of that power
Yes.
because you can I learned this several years ago. You can assign multiple powers of attorney to different people. Like you could have one that handles your medical and one that handles your, this area and one that handles, that area. Maybe you have someone you trust to make your medical decisions, but, they're not a great
Financially
financial,
savvy. Yes, yes. So when I sit down with clients, I do ask more about who they're naming. Is it a child that we're maybe a little concerned about their ability to manage finances? If they're struggling with their own finances, we certainly don't want them acting as an agent or not acting alone as an agent on a power of attorney. But maybe they're fantastic in an emergency medical situation. Well, great. We can absolutely have them as the primary on the medical directive. So you are exactly correct. It's a thought process of who we are naming and who is the best fit. There is no specific answer and there is no right answer. So it's not that we need to name the eldest child on everything simply
right.
because they are the eldest. No, we want to make sure we have the best fit for each person, that they're in a role that makes sense and that the client is comfortable with. And like you said, that power of attorney is very broad. It encompasses a lot of power and a lot of authority. So it needs to be someone that we trust completely.
Right. And so going back to the guardianship, I'm in a situation where someone is incapacitated and they do not have the cognitive ability to make their own decisions.
Right.
What if there is no one to be
That is
willing
hard.
to
That is difficult. That's where there are some companies locally in our area that are able to step in and manage care for that person, whether it is acting as a guardian and conservator financially, or whether it's stepping into that role for medical decisions? That's where usually there's a third party to be able to come in and step into that. And unfortunately, if not, that's where we rely on other support services and to have someone named to be able to step in.
okay. And but those third parties, I'm assuming, need to be compensated. And so
Correct.
if
So there usually is a charge or a fee if it's a third
right,
party.
right. So there has to be some value in the person's estate to be able to cover those.
Typically, there are some circumstances, though, where the state would be able to step in and compensate,
Okay.
but that is a very long process, a very
Right.
difficult process to go through.
Yes. So we talked about wills a little bit. We talked about power of attorney, trusts. I know there are a lot of different kinds of trusts,
Yes.
and that's about all I know about trusts. I've had a few conversations about what those might be and how those might be used. But talk a little bit about the different types of trusts and who should consider getting a trust and what type of trust would what are the pros and cons of the different.
So in Virginia, we have a couple different types of trust. There are so many different types. So sometimes someone may need what's called a special needs trust. If they have a beneficiary or if they are a person under a disability, and we need to ensure that they're able to still receive their benefits, either state or federal benefits. And we've got to walk that fine line between how much someone could inherit or money they could have access to maintain those benefits, then it may be a special needs trust. If someone wants a standard trust that you hear about most often, where they could put assets into it but change their mind later, that's typically a revocable living trust. That's the most common type of trust that allows someone to establish a trust while they are alive, potentially move assets in and out as necessary. And then when they pass, that trust typically becomes irrevocable, meaning that it can't be changed. So if it's a singular person, and they put assets into a trust, they can outline what they want to have happen with those assets after they pass. And overall, a trust gives you more control for a longer period of time. You can deal with a lot more what ifs that may pop up. And a trust is able to be in place for generations, certainly decades. So if someone has created one while they're alive, they may move assets in or out. And then when they pass away, they could have something as simple as, oh, it's divided equally between my children. Or they could have something more complex and say 40% to each of my children and the remaining 20% between my grandchildren. But maybe we add another level and it's to my grandchildren after they are over the age of 30 and they have a full-time
Okay.
job. So each of those different parameters you can put into a trust and allows you to have more control over what assets are distributed to which beneficiaries and when. So it's not necessarily based on a certain dollar amount. Certainly, if someone wants to be able to control large sums of money, a trust makes sense, but it's not always necessary. It really just depends on each circumstance. If you look online you're going to see you absolutely need a trust no matter what. But that doesn't take into consideration, especially in our area, financial circumstances. People pass away all the time without any sort of estate planning, certainly without a trust. So it's not that trusts are necessary in every single circumstance. They're a very useful tool, but sometimes they're overkill. Sometimes they're a little too much, especially if a person doesn't utilize their trust or doesn't understand what they have, or if the family doesn't understand what the trust is or what it does, and then they end up paying a different attorney down the road to simply dissolve it or to explain it. We want to make sure before someone is engaging in that and setting up such a large document that that's truly what they need. And really, it boils down to what are you hoping to accomplish? What are our beneficiaries like? What do we want to have happen rather than a certain dollar amount?
So, but would it be fair to say that trusts are typically utilized by people with a higher net worth?
Yes, I think that would be fair to say. They're typically utilized by
Okay.
people with a higher net worth, but I think that also goes in line with people with a higher net worth have more advisors and are more open to conversations about complex estate planning. So it's that
Okay.
they're already in a area where estate planning is the norm, where having advisors, certainly financial advisors or estate planning attorneys is the norm. So they're already in that role, having a complex board of people to help them.
Right. And maybe there are people that own multiple businesses and multiple properties
Correct.
and there's
Correct.
different ownership. Maybe I have 50% ownership in this asset and I have 20%
Yes.
ownership in that asset over there and I have, some
Yes.
interest in an overseas property or
Then
whatever
certainly,
it may be that's
yep. Then
that's
you would
not.
certainly want a trust. So a trust helps you corral all those different pieces. So if it's someone that's got a lot
Yeah.
going on, you're probably going to end up with a trust to help corral all those different pieces into one main area and then from there handle the distribution.
Right. Right. Okay. And then I've heard of a living will.
So a living will is a similar name for an advanced medical directive. It's kind of the more
Okay.
common phrase. Advanced medical directive doesn't exactly roll off the tongue, but your living will sets out your choices for end of life health care, typically life support, or other end stage health care. Your living will sets out what you would want to have happen, if you'd want that withdrawn, and in what sort of circumstances. And that allows you to make those choices ahead of time rather than having family members make those choices at the hospital or in an emergency situation.
So something like a DNR, do not resuscitate order would be something that, if you decide ahead of time that if my heart stops or if this happens or this happens, I don't want this level of care. I want you to let
Right.
me.
So the
Yeah.
do not resuscitate order is typically put in place with a physician so they can explain all of the consequences and exactly in
Okay.
detail what a DNR does or doesn't mean and walk through those kinds of examples. So a DNR is usually with your medical professional and is just a small piece of your overall healthcare directive. Yep.
Gotcha. Okay. So how would somebody, let's say somebody's got an advanced medical directive and they have decided, what their wishes are with regard to medical intervention in different circumstances, and they have that document all legal and it's
Yeah.
filed, but how do you communicate that to your medical team? Now, if you have a family doctor and, you just let them
Right.
know give them a copy of it. But let's say you're on vacation
Yes.
and you're in an automobile accident in another state and they
Correct.
rush you to the hospital. They probably don't know that
They're not
you
going to know.
have that document in place.
Correct. So I've actually had this question come up. I have had so far as a person in a presentation suggest that they have a copy in their glove box for that kind of circumstance. I don't know though that first responders are going to go through your glove box and find that.
Right.
So in that case, I recommend having an electronic copy and having your agent have an electronic copy. Certainly in that circumstance, in a car accident, first responders in a different state are most likely going to render aid because they don't know. They don't know that's what your medical directive is.
Right.
Their job is to render that aid to you, get you to the hospital. That's what they're going to do. And they're going to follow through with that. After that point, once you arrive at the hospital and your agent under the power of attorney arrives, then they would have that with them. So I do recommend once you have that medical directive done, uploading it to your, whether it's your MyChart or whatever kind of portal you have with your doctor or your hospital system. And there is a Virginia Advanced Directive Registry, although it's not as commonly used. And then certainly once you have that completed, sending that to your agent and your backup agent on the medical directive. So they have a copy as well. So if you were out of town and in an accident, they would have a copy of that and they could provide that to your medical team there, wherever you are, or bring that with them to the hospital.
Right. Okay. Once I start thinking about scenarios, I mean, you can just go on and on and
Yes.
on, right? Because it's like, well, what would happen in this scenario and what would happen in that scenario? And I don't know if there's any like nation electronic medical records or anything of that nature that brings up privacy concerns, but
Right.
for
And
the
with,
scenario
yeah.
we talked about, it might be helpful for, a hospital to be able to look up somebody's history. They're brought in unresponsive to be able to know, or some way to access their medical records and say, oh, well, they're allergic to this, or they're, whatever
Right. And
information that.
that is difficult with each of our different healthcare systems. Virginia alone in our area, we have 3 or 4 different healthcare systems. And then you go out of state or out of the country and certainly it is difficult to have that. So I do recommend at least your agent having a copy, and if someone wanted to carry a copy on them or in their wallet or in their purse while they're traveling, that way they'd have at least a copy with them, if that happened. But there are a lot of circumstances where someone is rendered aid or they arrive at the hospital and we don't have that kind of information.
Right. It's a lot to think about.
It is.
So
It
we've
is.
talked about wills, we've talked about trusts, we've talked about power of attorney,
Yeah.
advanced medical directives. What have we left out?
Those are typically the primary estate planning documents. Occasionally, clients may come in and want either a deed of gift to gift property immediately or like a transfer on death deed to transfer real estate after they have passed away. So it's working through that to figure out what their goals are and what makes the most sense. But certainly deeds are usually a part of estate planning process as well. That's usually the world of it. There's not 100 different documents to go through or even a dozen. It's just within those documents, making sure that they fit what each person needs.
And Some of these decisions have tax consequences, obviously. Do you render
So
tax advice? Do you
I don't.
collaborate with tax professionals when
Yes.
people
Yep.
ask you, what impact is this going to have, on my taxes or my heirs' taxes?
Right.
How do
So
you handle that question?
I work with their tax professional. I don't render tax advice, but I work with their tax professional to say, if we do XYZ, here's what's going to happen. Do you want to do this? Is this something that you want to gift now? And what kind of tax consequence does it mean to gift it right now? Or is it something that you want them to inherit? And we walk through basic information on inheritance in Virginia. But as far as tax questions, that's where we work hand in hand with their advisor, with their tax professional to ensure that we are accomplishing their goals and not ending up with any sort of unintended consequences. But it's not normally that complex. I don't want to scare anyone off by going through all these what ifs because the worst document is one that's not completed. Is a, well, maybe someday I'll get to it, or I've always meant to have a will and it never happened. And now I have families call me on hospice. My loved one is on hospice and they only have a week and we want a will now. That's not realistic. And that's sometimes not possible. Most of the time, not possible. And usually not realistic. So you want to make sure that people don't put this off because they think they need all the answers ahead of time. The best step is the simple first step is reaching out, either going to an educational seminar or reaching out and making a consultation. And if it turns out you need a second meeting or you need more details, that's okay.
So we hear the word probate a lot, and I don't know that I completely understand what that term means, and I assume there's probably some listeners that don't understand what it means either.
Yeah,
So could you kind of
absolutely.
explain when we hear probate, we talk about we want to avoid probate. What is probate
Right.
and why do we want to avoid it?
Probate gets a bad reputation. It definitely does. Probate is a process, and it is the process of your will being taken into the court, the local court where you pass away or live, and the county and the state overseeing the distribution of your assets and the settlement of any debts that you may have. So when you hear about probate being a problem, that's because there is some sort of underlying problem either in the family or with an asset that didn't get addressed ahead of time. The probate process itself is just paperwork. So if someone's good with numbers or they're great with a balance sheet, they'll be able to handle probate no problem. I have run into a few people that were fine, totally fine with the process. Some people need the assistance of an attorney if it's a complex estate, but most times families handle the probate process themselves by working with the clerk's office and by following this procedure that are set out. It's well documented in Virginia. They walk you through each of the different steps, the rules and regulations to be able to oversee assets getting from the person that passed away to their beneficiaries. Now, people want to try and avoid probate because occasionally probate can take a long time. There have been estates where probate takes years. And that's the ones you hear about. You hear about the ones that take forever, or there's litigation, or there's a problem. We want to try and avoid that and streamline that process for your own peace of mind and for the benefit of your beneficiaries and your executor. So, if there are ways that we can accomplish that and avoid having assets pass through probate, we're going to try and do that. And I would say that's probably level 2 of estate planning is what do we need and then how to avoid that probate process and make it a
Right.
little easier.
So what is the responsibility of the executor to find the heirs that are named in a will?
Yes. So your executor has, like you said, has the responsibility to find those heirs, to notify those heirs of the existence of the will of that person passing. And the county is going to ensure that those heirs were contacted or had the attempted contact if necessary. Certainly, there are circumstances where someone has either passed away and we were never notified, or there is an heir that just cannot be found for whatever reason. It's more unlikely in this day and age when we have that sort of information on everyone. But certainly it does happen where heirs can't be found or don't respond. So the county and the commissioner of accounts ensures that that process is met and that heirs are contacted about someone passing.
Well, it's interesting because, and this was years ago, this was probably 25 years ago. And I get a phone call out of the blue, and the guy on the other end of the phone says, "Is this your name? And is this your brother's name? And is this your sister's name?" I'm like, "Yes." And he said, "We have found some money that is due to you." And I said, "Really? Send me the information." So he sends me this agreement, and the agreement says, you have been named in an inheritance, and for the mere sum of 40% of the amount, I will, tell you where you can get it. And I thought, 40%, that's
No.
highway robbery. So I called my dad and I said,
Yeah.
"Do we have any relatives that have passed away?" And he said, "Well, my cousin Charlie, died, he was hiking on the Pacific Rim, and he
Oh
fell
my
and
gosh.
was killed." And so, I knew where he lived. So I called the county courthouse and I asked them if they had an estate in his name, and they said yes. And they told me who the executor was. And I called up the executor, and he said, yes, there is. There's $10,000 for each of you. And all I need is a notarized copy of your driver's license and $450 and send it to you, which was way less than 40%.
40%.
Right. And so my brother and sister split the $450, and, we all got a check for $10,000, which, that was some years ago before finding people was as easy as it is
Right.
today. But that was certainly an interesting experience.
Yes. And those rare circumstances do still happen where a distant family member or someone without children names distant cousins or other younger relatives,
Right.
and those things do still happen.
Right. Well, because he had named us in his will when we were small children, and the address was the farm where we grew up, and that had since been sold.
Mm.
And so, that was
Right.
that was why they didn't know where we were. And we had all grown up in the meantime and,
On that
lived
note, it
all around the
is
country.
it is important for people to update their documents. So that's a common question I get as well is if I put documents in place, how often do I need to update them? Well, there is no set number. Certainly if something major has happened. So if your beneficiaries went from being minor children to grown adults and we're decades later, we need to update that. We need to make sure that
Yeah.
we've included updated information. But similarly, if you have a primary beneficiary who has passed away, we need to update your estate planning at that point. Not always, but usually it's best to update at that point to make sure it's clear of who is supposed to receive things now. There's no unintended consequences. So, for example, if someone has an adult child pass away, we want to ensure that it's very clear of whether it's supposed to go to grandchildren or remaining adult children and clarify that. So I do recommend people update their estate planning documents every few years or at least review them to ensure there's nothing that needs to be changed.
Right. Right. So, wow, we've talked about a lot here, and I'm assuming this is a lot of what you cover in your seminars, the basic
Yes.
different documents and considerations, and what do you do if you have a number of children, but maybe, one or two of them is estranged, or you have a difficult relationship, and how do you handle that? And if you have someone with special needs who needs more ongoing support maybe than your
Yes.
other children, and there's definitely some decisions to make in all of
Certainly.
this process,
Certainly. There are
which
a lot
which
of
might be
decisions.
which might be part of why people avoid it. And the other part, of course, is that anticipating your own death is not the most pleasant pastime to engage in, right?
True. True. I do get that a lot.
Yeah.
I have people who are afraid that or superstitious that if they put these documents in place, they're going to pass away soon after that. No. I'm glad that that's not true.
Yeah.
But
Yes.
waiting
Well, and
waiting
I
doesn't help.
right. And I get that same reaction a lot in talking to people about modifying their homes or making their homes more accessible or creating an accessible bathroom or putting in fall prevention or creating a zero-step entry or any of those kind of things to their home because of what it makes people think of.
Right.
I remember a conversation I had years ago. Why is it that people will save money for retirement all day long and they'll sign up for a seminar on putting money in their 401k, But if you want to have a conversation with them about a will or about a grab bar in their bathroom, they don't want any part of it. And the person I was having a conversation with said, well, that's easy. It's because when they're saving money in their 401k, they're thinking about all the fun things they plan to do. They're thinking about traveling and walking barefoot on the beach and driving their convertible on a sunny day. And when they're thinking about a will or a grab bar, they're thinking about being disabled or being
True.
dead. And so I think that's why education is such a big part of what you do and what I do,
Yes.
because you kind of have to work people up to it sometimes, I think.
And certainly for both of us, being approachable, being able to bring a different lens to it. It doesn't have to be, building specs and anything like that. They don't need to have all the answers on the exact size and how to install things because you have all of that knowledge. And on the estate
Right.
planning, I have the ins and outs of each of the different documents and what we need to put in place and what works best. And they don't need all of that knowledge. So it's being able to be approachable, have people sit down and have it be more of a conversation and that educational piece to make it more approachable. So that's certainly what I hope to do with Wills on Wheels and have more people be able to do that.
Yeah. Well, and just getting people to decide they're going to do it, right?
Yes.
I mean, that's 90% of the battle.
Yes, definitely.
So I want to tell you a story. You may have heard this story, but this was a story that Bob Birch told me years ago. And, for our listeners, Bob was the previous Wills on Wheels,
Yeah.
and he had stopped somewhere. It was like a dry cleaner or something, and dropped off his dry cleaning. And they asked him, what he did, and he said, "I'm Wills on Wheels." And the clerk said, "Oh gosh, I wish you were Meals on Wheels." And he went out and bought a pizza and brought it back and gave it to him. He said they were so embarrassed. He said, "I was just kidding. I was just kidding." Hey, there's two of you.
I know. Two different phones. So we're just jumping back and forth between the two.
Okay.
But I do get called Meals on Wheels
Yeah.
regularly.
Yeah. So thank you very much for this conversation, Sarah. I've really enjoyed it. And so
Absolutely.
for people that would like more information, would like to know where and when one of your seminars is, or would like to make an appointment to have you go over their documents with them, how do they get in touch with you?
Certainly. So I'm online. You can find my website, willsonwheelsofva.com. So certainly you can find me online. I am also on Google Maps. So just search Wills on Wheels and you'll be able to find me there as well.
Okay. Awesome. Well, thank you so much and have a wonderful day. And I'm sure we will talk to you again soon. And for our listeners, thank you for listening to Aging in Place is a Team Sport, and continue to come back each week for more conversations with people that make aging in place possible, safe, and effective. Have a great day.